Social Justice Lecture Series. I'm Nancy Davenport. I'm the University Librarian, and we are one of the sponsors of this series. And through the series, we bring to campus exemplary leaders from diverse backgrounds who are advocates for human rights and for social justice issues. And today's speaker, Catherine Ross, who will be talking on silencing speech, diminishing discourse, threats to democracy on campus and beyond. Catherine is a professor of law at George Washington University, and she'll be analyzing contemporary controversies over the expression on college campuses and beyond through the lens of the First Amendment doctrine. She will discuss lessons in censorship that we've learned from kindergarten through high school, critical distinctions among censors and speakers on college campuses, and the importance of active citizenship in a pluralist democracy. As a librarian, these are topics that are very close to my heart. Are any of you student workers in the library? No. If you were, when you come for your first orientation, I walk in and all the students expect that I'm going to tell them about the time clock and checking in on time and et cetera, and I don't. That's their supervisor's job. I talk to them about having joined the library as the first defense of the right to read freely. And I tell them what to do if the FBI shows up and wants to take out a computer or see our records. We protect your privacy. We protect your right to read freely. When you check out a book from the library, that's a business transaction. We need to know who has it. But the moment you return it, we break that record so that you can never be identified with having checked out that book. We do collect statistics off of it to know that it was a student, a graduate student, an undergrad, a grad, or a faculty member. And that's all we need to know. We need to know how our collection's being used and that it is being used, but we don't need to know who uses it. So you will find us highly aligned with the attributes and the essence of the right to read freely and free speech. Catherine Ross is Frederick C. Stevenson Research Professor of Law at George Washington University Law School. Her most recent book, Lessons in Censorship: How Schools and Courts Subvert Students' First Amendment Rights, published by Harvard University Press in 2015, was named the best book, show and tell, was named the best book on the First Amendment of 2015 by Concurring Opinions First Amendment News. And it won the Critics' Choice Award for the best book of 2016 from the American Educational Studies Association. Professor Ross has spoken and written widely on freedom of expression on college campuses. Her current research focuses on lies and the First Amendment. Professor Ross, we are so pleased to welcome you to American University.
Thank you so much for that wonderful introduction. And I am a great fan of librarians. They are on the front lines every day of protecting our society and individuals from censorship. I want to thank the library for inviting me to this really phenomenal series on such important issues, and Dania Freeman for her hard work in putting this together, and all of you for coming today. I wish my talk today were less timely, but it could hardly be more urgent. Expressive rights are under the spotlight, and many would say under siege, on campuses at every educational level, from elementary school through universities, and they're igniting controversy in the country at large. Early in his term, President Trump called the press the enemy of the people, a phrase resonant with Stalinism, Nazism, and other authoritarian forms of government. And just last week, he said, "It's frankly disgusting the way the press is able to write whatever they want to write. People should look into it." He's called the NFL players engaged in protests aimed at police brutality and racial injustice sons of bitches, and urged their private employers to fire them for their views. These attacks on free speech are so dramatic that one Republican senator, Ben Sasse of Nebraska, asked the president last week, "Are you recanting your oath to preserve, protect, and defend the First Amendment?" A very good question. I'm going to start today with a very brief overview of some key First Amendment principles protecting free speech, And then I'm going to turn to what students learn about free speech in primary through secondary school. When I use the word school, I mean K through 12 as opposed to colleges. And then I'm going to talk about what happens when they arrive in colleges and some of the incidents we've all been focused on in the last 2 years. Talk about the relationship between speech on campus and in the broader society, including the impact of events in Charlottesville, which stands as a symbol of many incidents, although at an extreme, and finally, why speech matters to democracy. The speech clause of the First Amendment is very concise. All it says is, Congress shall make no law abridging the freedom of speech. As interpreted by the Supreme Court over the decades, this means the government at every level, from small towns to the federal government, and anyone acting on behalf of the government, may not silence or punish speech because of its content or its viewpoint. The First Amendment doesn't limit the ability of private persons or organizations, including employers like the NFL, to restrict expression if they decide to do that. And yet many private organizations, including colleges, voluntarily commit to respecting expressive rights. Free speech is an essential building block of democracy. The Founding Fathers believed, and I quote, freedom to think as you will and to speak as you think are indispensable to discovering political truth. They were also concerned about personal autonomy and the importance of free exchange of ideas for discovering the meaning of life, an endeavor people are very much engaged with while they're in college. In the words of Justice Brandeis, they believed liberty to be the secret of happiness and courage to be the secret of liberty. The central precepts of the speech clause that bear on my comments today include, first, the state, including public schools and public colleges and universities, can't discriminate among speakers based on content or viewpoint. Second, censorship includes both silencing expression before the speaker can share it and punishing it after it is voiced. Generally, the government cannot punish constitutionally protected expression, which doesn't include certain very narrow categories of speech, including obscenity, defamation, and an extremely narrowly defined group known as true threats. The First Amendment does, however, protect what most people think of as hate speech. When courts examine the claims that government interfered with free speech based on content or viewpoint and its protected speech, the presumption is that the government's restrictions are unconstitutional. It's a very, very hard standard to meet. Third, the Constitution teaches that the best response to noxious speech is more and better speech. In a marketplace of ideas, we assume better speech will normally prevail. Sometimes that's a risk. Fourth, and finally, the speech clause exists to protect the dissident, the least popular, or in modern terms, the least politically correct speaker and the least politically correct ideas, often referred to as the thought we hate. The speaker most people agree with does not need the protection of the First Amendment. So what is going on in our public schools, K through 12? What are kids learning about the First Amendment? And so my starting point is the fragile state of student speech rights in elementary through high school, the subject of my book, which you've already seen. Nearly 90% of American students today still attend public schools, and so they are our best vehicle for transmitting our core democratic and constitutional values, including pluralism, respect for other people's ideas and ways of life, and the meaning of civil liberties. But instead of modeling freedom, public schools in every part of the country systematically violate students' First Amendment rights by silencing and punishing speech that the Constitution protects. In the process, they fail to transmit an understanding of why we have free speech and how to exercise it. And they give students misleading and inaccurate messages, including the message that you can and should expect to be protected from words and ideas that offend you, and that the state will do that protecting. Students do have First Amendment rights in schools, but they're different from the rights that prevail outside of school and for adults. That doesn't mean that schools may overrun individual rights, just that when courts review censorship at schools, they apply more forgiving legal tests. They give school administrators and teachers more leeway than the state would otherwise have because of the importance of the educational function and the fact that students must be in school. A series of Supreme Court opinions beginning in the 1960s created a special doctrine for evaluating whether a school that censors student speech has violated the First Amendment. Tinker versus Des Moines in 1969 was the first case to craft a special rule for students. The court stated that a school violates student rights by censoring speech unless it can show, with evidence, that it reasonably anticipates that the speech will cause material disruption or collide with the legal rights of others in the school. And it took a very vibrant view of speech rights in that case. It was a case involving students who were suspended for wearing black armbands to protest the war in Vietnam. And the court held for the students. It took for granted that the classroom itself is indisputably a place for the free exchange of ideas and sought to expand those rights out from the classroom to every part of the campus. It held that more than reasonable school rules were required before schools could silence expression. And I quote, "In our system, undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression. Any departure from absolute regimentation may cause trouble. Any variation from the majority's opinion may inspire fear. Any word spoken in class or on the campus that deviates from the view of another person may start an argument. But our Constitution says we must take this risk. We must take this risk." And elsewhere, the court has underscored that we are a disputatious society. So part of learning the mantle of citizenship is learning how to respond to difference, how to hear it, and how to engage with it. As the court became more conservative, each Chief Justice presided over a case that cut back on student speech rights. The court carved out a series of exceptions to the material disruption principle that protected student speech. These exceptions give schools enormous discretion to censor speech that is lewd or has sexual connotations, that appears to advocate the use of illegal substances, drugs, and underage drinking. You may recognize this as the Bong Hits for Jesus case. And the most important exception reaches a great deal of speech. This is where the court invented a category called school-sponsored speech, in which the school comes from the students, but a reasonable observer might think that the school itself gave the speech its imprimatur, approved the speech before the student issued it, and it becomes what Justice Alito has called the school's own speech, and they may censor it for any legitimate pedagogical reason, which means pretty much for any reason at all, as long as they bother to state one. And it allows schools to censor almost all school publications, performances, and a great deal more. So these rules create a taxonomy of student speech rights with different legal tests depending on the category of speech, and it's very hard to understand and administer. But even given that difficulty, schools push beyond the enormous leeway that the law's given them. They regularly censor protected expression through a combination of ignorance of the law, disregard and disdain for the law, leading one student to sum it up: "My school is all about censorship." Classroom discussion and materials are increasingly sanitized and limited to avoid controversy about historical and contemporary events. And what students themselves say has become a recurring cultural and legal battleground. Schools punish and silence students who express their own opinions on every political side of important debates, including LGBT persons' rights, guns, abortion, and more. One school suspended a 6-year-old who called a classmate a poo-poo head. Another stopped an elementary school girl from praying before eating her own lunch. In the upper grades, schools suspended a boy who wore a political T-shirt that praised the Marines and their rifle, and another who called out gays, Muslims, and abortion in equal opportunity. Students have been sent home for wearing pro-Trump shirts and pro-Hillary shirts, both during the election and since it ended. The Constitution protects all of this expression, as well as speech that adults dismiss as worthless, including adolescent humor that is beyond adult comprehension. Students are especially likely to get in trouble for speaking up if someone else's parents finds their speech controversial or offensive, meaning the adult disagrees with it and goes into school to complain. Schools commonly restrict the expression of creative artists who were punished for using curse words or rude language or for quoting those words from published works, including very distinguished works like Chaucer, and for plots and drawings that school authorities think someone might find threatening. Students often explain, "I was just trying to capture the way real people talk." So one appellate judge sounded an alarm. High schools, he wrote, should not be, quote, cozy places like daycare centers where no one may be made uncomfortable by the knowledge that others have dark thoughts, and all the art is of hearts and smiley faces. Most recently, there's been an explosion of incidents involving penalties schools impose on students for what they say from their homes, outside the school day, off the school campus, often on social media using their own equipment and networks, places that the school has no business prying into and no authority over. The off-campus expressions schools punish include sexting, texting, and bullying words without any physical contact, whether addressed to peers or to adults who work at the school. Apparently, in the eyes of school officials, one of the worst things a student can do is criticize a teacher, a coach, or a principal. Whether couched in rude language, a satirical social media page, or simply put, "I hate Miss Phelps," schools call this harassment, and they say it's against school rules even when it takes place off campus. This increasingly important arena for censorship tells students that the authoritarian state is all-powerful and it watches you 24/7. It undermines one of the core principles of democracy. Every person has the right to criticize the powerful, whether the powerful person is a teacher, a coach, or the President of the United States. The bottom line, educators in grades K through 12 continually teach students that the First Amendment is a sham, something for the ages, but not for them. Students get the message, and it's a message that conflicts with constitutional norms, that as a society, we value order over freedom, quite the reverse is true, and that we're more concerned with hurt feelings than with liberty. Given this experience, we shouldn't be surprised that teenagers arriving at college often fail to comprehend the speech rights of others and don't know how to exercise their own rights. They haven't been encouraged to take either set of rights seriously. And so recent survey data suggests that young people have a very constricted understanding of speech rights. Before I share some of that data, let me just share my reservations about surveys, because we don't always know how deep they go when people respond. I often find that students are amenable to rethinking their positions about free speech when they're exposed to more information about the Constitution. So that said, here are some findings. In 2016, the Knight Foundation reported that 91% of high school students agreed people should be allowed to express unpopular opinions. So far, so good. But when asked follow-up questions, only 45% agreed people should be allowed to say what they want in public, even if it's offensive to others. The attitude of students toward free expression is not simply a patchwork of politically correct views. But it's something that a museum analysis this year termed more worrying. Young people, the museum said, seem to have, quote, an alternative understanding of free speech that is essentially the right to non-offensive speech. And confirming this, just last week, the leading national organization that fights for speech rights on college campuses, the Foundation for Individual Rights in Education, known as FIRE, released its annual survey of college students. More than half of the FIRE respondents said it was very important to them to be at a college community where they were, quote, not exposed to intolerant or offensive views. As a First Amendment scholar and an educator, I'm particularly disturbed that students actively seek colleges that won't expose them to offense. Why? What's so special about colleges? Well, the classic liberal arts education aims to teach students how to think critically. And most college students in the US attend public colleges run by the government, where the First Amendment is mandatory. A majority of the students who attend private or nonprofit colleges, like this one, also attend schools that have voluntarily undertaken to respect freedom of expression. And when they do that, we expect them to be guided by First Amendment principles. That's what freedom of expression means, and it goes far beyond what we usually capture in the term academic freedom. So let's move briefly beyond the First Amendment at colleges. Private universities committed to free expression have produced 3 seminal reports on the special and unique role of free expression in the academy over the last half-century. Together, they explain why free expression matters so much in higher education as opposed to other kinds of environments and institutions. And they set out some of the principles that I think should guide our current discussion about what's going on in colleges. In 1974, and I see a few people who may remember this, hecklers prevented a scheduled debate featuring William Shockley at Yale. Shockley was a Nobel Prize-winning physicist who went outside his expertise to promote his own view that blacks were genetically inferior to whites. And the events surrounding his aborted talk looked a lot like recent incidents, particularly those involving Charles Murray speaking about the same topic, and they received national attention. In response, Yale issued a very thoughtful report on the conditions governing free expression on campus. It was authored by C. Vann Woodward, the most eminent historian of the South of his generation, and someone who was acutely aware of the role that protest could play in changing society. Woodward emphasized several important values: free expression, peaceful dissent, mutual respect, and tolerance, but insisted that free speech overcomes all of those priorities when they're in conflict, including, most centrally, the important value of decent respect for others. And the tension between those sets of values is exactly what's at issue on campus today. The Woodward report rests on the premise that intellectual freedom and growth and discovery require, quote, the right to think the unthinkable, discuss the unmentionable, and challenge the unchallengeable. That belief, he said, is embodied in American constitutional doctrine, but not widely shared outside the academic world. Universities are different because their central purpose is unfettered intellectual inquiry, discovery, and dissemination of basic knowledge. And so, Woodward said, in words that still resonate today, the university can never let other important values, including, and I quote, friendship, solidarity, harmony, civility, or mutual respect, take precedence over the free flow of ideas, including the ideas we hate. The report highlighted the university's commitment to protecting speakers whose views contradict majority opinions. When tough choices need to be made, it may sometimes be necessary in a university for civility and mutual respect to be superseded by free expression. And joining a university community constitutes an undertaking to live by that principle. And these general principles appear as well in the two other foundational reports, both of which come from the University of Chicago, and both of which were written by eminent First Amendment scholars. Writing in 1967, a time of political and cultural cleavage, Harry Calvin at Chicago reiterated the distinctive mission of the university, which requires the widest diversity of views, and universities thrive, he said, on full freedom of dissent. A new generation revisited these issues in 2014 when Jeffrey Stone again talked about these things and added, it's not the proper role of the university to attempt to shield individuals from ideas and opinions that they find unwelcome, disagreeable, or even deeply offensive. When individuals on campus are offended, Stone urged, they should respond where needed, not by seeking to suppress speech, but by openly and vigorously contesting the ideas they oppose. In other words, engaging. This is classic free speech doctrine without exception or gloss applied to the college. The best response to bad speech is more and better speech. And it provides the needed background for a statement that one of the deans at Chicago issued last year to incoming freshmen, where he warned that upon enrolling, they should anticipate challenge and even discomfort. Sadly, not all university leaders agree. Most dramatically, perhaps, in 2016, Morton Shapiro, president of Northwestern University, defending safe spaces there, dismissed First Amendment concerns as those of, quote, lunatics and idiots. We can't allow those views to gain traction. We must allow them to be voiced, if Shapiro wants to say that, but First Amendment doctrine has never entertained the prospect that equality and dignity can outweigh freedom of expression, or that speaking for freedom of expression is lunacy. As the Roberts Court said recently, the Constitution, here I'm paraphrasing, the Constitution made that choice for us. We can't have that values debate. It isn't up for debate. In short, free expression at college is not just a matter of law or luxury. It is the Academy's central mission. And as Harry Calvin advised in 1967, and one cannot say it often enough, a good university, like Socrates, will be upsetting. That doesn't mean that anything goes on a college campus. As I mentioned in discussing First Amendment principles, some categories of expression are excluded from the First Amendment. The state doesn't need to tolerate incitement to riot or true threats, even on a college campus. And the First Amendment also distinguishes between expression and conduct, though the line is often murky. Conduct that violates constitutionally permissible rules. In other words, rules that aren't really secretly trying to get at viewpoints or expression, but really are about conduct in the world, that may always be punished without violating a speaker's rights. And some, perhaps many of the incidents on colleges in recent years involve a mix of conduct and expression. So what's actually going on at college campuses amid all this noise, press coverage, and public attention? The word crisis comes up repeatedly, but I think that's a bit overblown. Last year, PEN America produced a terrific report on the state of speech on American college campuses, and it concluded, and I agree, that there is no pervasive crisis for free speech on campus. But there's much cause for concern if current trends continue. We shouldn't let the focus on dramatic events that bring tensions to the surface mislead us into thinking that all colleges or all of campus life at some colleges are dominated by political and cultural conflict captured in divisions over speech. Yet there's no denying that many of the controversies on college campuses in the last 2 years have centered on or implicated speech rights. Turmoil has surrounded the speech of fellow students, of residence hall administrators, of faculty, of colleges themselves in the names of buildings and schools, artworks, and objections to invited speakers. Students, administrators, and sometimes even faculty members who should surely know better have sought bans on speech and official punishments. Advisors have told students and faculty to use certain words cautiously and to avoid the newly minted category of speech known as microaggressions. And students have often been in the vanguard, seeking the support of universities in silencing their peers, faculty, and speakers. Many of you, I'm sure, know that this campus has not been immune to speech controversies. So just a few examples. Last year, bananas were used as symbolic racial epithets. And again last May, bananas were hanging from nooses around the campus, along with racist messages. And this fall, I gather, Confederate flags adorned with cotton appeared. And just last month, an event was canceled when the university was reported to have suddenly discovered a shortage of space, months after a student group reserved a room for a panel on feminism, free speech, and Title IX, and the American Association of University Women had objected to the position they thought the panelists were going to take. Ironically, the panel included renowned free speech advocates, including Nadine Strawson, the immediate past president of the ACLU, and Laura Kipnis. The event had to move off campus, where it proceeded without incident. We should not lump all of the speech events together. Viewed as a matter of constitutional law, there's a lot that distinguishes the events from each other. It's important to disaggregate the kinds of speakers on college campuses. My own work has focused primarily on student expression, but we also have to think about others who are under challenge. Faculty members who are challenged in their work, their classes, and in what they say in their free time. Administrators who are also speakers and who are entitled to share messages, often messages designed to counteract offensive speech and reassure the population on the campus. And at the center of recent fractious demonstrations, outsiders, some of whom have been invited pursuant to the school's regular procedures, like me, no protesters outside, okay. No. And those procedures vary from campus to campus. But other outsiders weren't invited by anybody. They rented space or organized a demonstration near the campus that impacts the campus, which was the situation in Charlottesville, where the protest was aimed at the city and took place under a permit that a court ordered the city to issue. And all these factual distinctions may matter to First Amendment analysis. The sources of censorship are much the same, as I indicated. Could be students, could be administrators making their own rules. And when there are rules against speech or widely voiced disapproval, that creates what in the First Amendment we call chill, which discourages people from exercising their speech rights out of fear. And most recently, people have been calling to disinvite and or silence controversial speakers, and sometimes shut down controversial events. So the rest of my comments are going to focus on these recent developments of controversial outside speakers and organized protests in response. And public attention has focused since this past February on violence, the potential for violence, and on canceled events, since provocateur Milo Yiannopoulos was invited to Berkeley in February, where a riot ensued when opposing groups demonstrated, and some people started fires and smashed windows. Quickly, we had the drowning out of Charles Murray at Middlebury and elsewhere, and the National Review keeps a running tally of what it calls shoutdowns, speeches that are shouted down or canceled in anticipation of vehement protest. And that is the heckler's veto, which is forbidden. Kurtz says there have been more, who keeps this tally for the review, says there have been more shoutdowns in the first 2 months of this academic year than in all of last year, and other cancellations where the speaker backed out, afraid of confrontation. Tomorrow, the contentious white nationalist Richard Spencer, whose followers convened the last 2 demonstrations in Charlottesville, is scheduled to speak at the University of Florida. Spencer led the Charlottesville white nationalists when they marched with lighted torches, which are illegal in Virginia, and they chanted racist slogans, including "Jews will not replace us," and veered off the permitted route onto campus. The next day, as I'm sure you all know, a member of their group weaponized a car, killed a counter-protester, and seriously injured 50 more people. We have a tendency in all these events to forget the injured. They also are going to suffer lifelong repercussions. The University of Florida has allocated $500,000 for security and said they did that even though there was no specific threat. But Monday night, anticipating the rallies surrounding Spencer's appearance, the governor of Florida declared a state of potential emergency, and he's considering activating the National Guard. We'll see what happens. So how do these outsiders come to campus? I've mentioned this in passing, but the most controversial in the news this year were either invited by a student group, often with funding from an outside political organization, or the speakers themselves used policies that allow people to rent space on university campuses, and so they invited themselves. No one from the university wanted them there. Last month, Milo planned a week he designated, ironically, Free Speech Week at Berkeley with lots of right-wing speakers, and they were invited by a student group. The students withdrew the invitation just a few days before the week was supposed to start, and they complained to the Department of Justice that the university had been hostile and had placed bureaucratic obstacles in their way. In fact, the university had rebuffed a plea from the mayor of the city of Berkeley that it cancel the event because he was worried about violence, and the university had planned to spend upwards of $1 million to ensure that everyone was safe. After the event, it turned out some of the speakers who were listed on the flyer said they'd never even been invited or heard about it, and it seemed to many people that this was a setup, that they'd never expected or planned to hold this series of talks. Milo came to Berkeley anyway, where he spoke for 15 minutes as a private individual, which doesn't require any planning, at Berkeley's famed Sproul Plaza, the site of the free speech movement in the 1960s. The university spent $800,000 to ensure safety and order during those 15 minutes of additional fame for Milo. More events, but I will move forward. So I mentioned the heckler's veto in passing, and to continue to talk, shouting down people, I just want to explain to you what it is. I've given you 4 principles already for the First Amendment. The 4th was the First Amendment protects the speech that we hate. And that leads to this 5th principle, which is the misnamed heckler's veto. It's a rule against hecklers. It is against the heckler's ability to veto a speaker by shutting the speaker down. And under the First Amendment, the authorities must protect the speaker from the hecklers and preserve the speaker's right to express himself. Sometimes the heckler only uses words, but so loud that they drown out the speaker, and sometimes they also rely on illegal conduct, including violence or threats of violence. For several decades, we've had the luxury of ignoring the prospect of violence at protests, at least on campus. But now we can't anymore. Now we have to triangulate speech rights, dignitary rights, Second Amendment rights. We can't discuss demonstrators with guns the same way we talk about protesters in general, even highly agitated demonstrators who lack the means to kill easily. Protest and counter-protest are long expressive traditions, and we know something about how to handle those two groups by inserting law enforcement between them, giving them different spaces that have a geographical separation and so forth. But flames, guns, sticks, and other weapons, including cars, should not be allowed at demonstrations. And law enforcement agents need to be well-trained and sensitive in the face of these challenges. I don't think that Charlottesville has to change or should be allowed to change the rules about freedom of expression. But it requires all of us, even the most tenacious protectors of free speech, to rethink what practical steps are required when marchers declare their intention to foment violence. That was online before Virginia. We also need to be prepared for unanticipated, unannounced violence that emerges in the heat of the moment. So briefly, what can colleges do? And I'm going to go through this really quickly. I'm sure you'll have questions about it. They have to keep everybody safe and protect their facilities. They can deny permission to speak if they have good evidence that violence is likely to happen, but we have to be very careful that they don't use that excuse too liberally. No pun intended. As serious concerns that some universities will cut down on speakers. They don't have to rent space to outsiders if they decide not to. Colleges should keep the distinction between conduct and speech firmly in mind. Conduct that is illegal or violent should be punished, even on college campuses. And in face of all of the brouhaha and canceled events, the University of Chicago once again took a leading role last June. It issued a statement on discipline for disruptive conduct, reiterating again, Chicago's one of the leaders in protecting freedom of expression on campus, but disruptive conduct will not be tolerated. We will punish our students, and we will bar violent protesters, individuals who we've identified. We reserve the right to bar them from campus. This is a blueprint. They haven't fleshed out the details, and of course that's where the devil lies, and much remains to be seen if they can develop a code that people will understand where the limits are. But people should be watching that. And we should distinguish initial invitations from disinvitations. No one has the right to be invited to speak at any given campus. But once invited, the heckler's veto principle comes into play. And there are lots of things you can do if you don't like a speaker that are totally consistent with the First Amendment. You can ignore the speaker, diminish them, turn it into a non-event. You can have a counter-event nearby or at a further distance. You can have peaceful protests outside the event that don't interfere with anyone who wants to go inside. You can attend the lecture, but not disruptive. You can have signs or T-shirts that challenge the speaker, and even better, ask really hard questions during the question period, which we will get to here. And administrators have set a great example at many schools by making counter-statements, both saying this speaker doesn't represent our values and reassuring vulnerable populations. At Florida this week, they've been holding seminars on the First Amendment to help the students understand why the university had to allow Spencer to appear. And they ought to promote better understanding of free speech rights and responsibilities from the moment students arrive at campus, because we know they haven't gotten that education in K through 12. So I regard that as remedial First Amendment education, which should accompany the training that most colleges or many colleges do today about diversity and respect for others. So freedom of speech matters because Justice Brandeis asserted that the greatest menace to freedom is an inert people. We do not want an inert people. We want active citizens. Learning to exercise your own free speech rights is critical. And that's also why we retain the right to criticize the powerful without fear of reprisal. All of us must speak out against the speech that offends us and the speech that wounds others. Students, for example, can take stands against vile and wounding speech by their peers, even though colleges can't punish that speech. You can make it clear to people in your dormitory. You can't speak in those kinds of racist terms and expect anyone to sit with you in the dining hall. Colleges can encourage and stand by those who stand up against wounding speech. These principles apply with equal force beyond the college campus in the broader body politic. Freedom of expression is not just an abstract ideal. It affects every important issue of the day, from healthcare to kneeling to sexual assault in Hollywood. And it requires both that we listen to each other and that we speak up. Thank you. I'm really looking forward to your questions.
Want to raise your hand? I have a mic.
Hi. So over here.
Oh, thank you.
So you spoke briefly about the speakers like Milo Yiannopoulos who were shut down. I just was wondering what you thought the effects of that were on...
About of shutting him down?
Yeah, so what the immediate effects are on his beliefs and how people perceive them, I suppose.
I think it gave him much more visibility than he probably deserved, because he, in my view, he is more of an entertainer and celebrity than a person speaking with serious intent. And you might say, why do I say that? Not because I'm dismissive of his political views, but for example, he engages in horrid disparagement of LGBTs, and yet actually he himself married another man in Hawaii a week or so ago. So I don't think he's a person to be seriously engaged with. I'm sorry, you're recognizing people.
Okay. So you just mentioned briefly kind of in the beginning about safe spaces, and I was wondering if you could just kind of elaborate on how you feel about safe spaces in particular, because, yeah, I just wonder how that kind of ties
It's a
into
terrific
all
question. It's a very complicated area, and my view, I hope, is a subtle one. I try to break it down a bit. If a safe space is, for example, a dormitory where people spend most of their time and never interact with other people of other groups, I have a problem with that, because I think it cuts students off from one of the most valuable parts of going away to school. At least if we're talking about, schools with dormitories, they're usually drawing from a wider geographical area. If we're talking about a place where you can spend a few hours, I think that's a different proposition, because if you understand the sociology or anthropology of college campuses, a lot of more powerful groups have always had a space that they can go to, a table where they sit together in the dining hall by general kind of understanding. So it depends whether it is going to be a broadly protective zone and a barrier to interaction, or a place to find people with whom you have a lot in common and who you can talk about things that perhaps other students may not understand as well.
Hi. Hello. Thanks for your talk. You sound like a First Amendment absolutist, which I am too. I'm interested in sort of the difficult question that arises with for example, a commencement speaker, where some of the normal arguments about being able to rebut offensive speech or speech that is difficult are difficult to address in that context, right? You can't typically ask questions. Everybody's graduating, so you can't have another seminar that would kind of discuss an opposing view, et cetera. How does that fit into the whole conversation?
Terrific question. First, and I said, think about who the speaker is and how they got there. A commencement speaker is very different from a Milo. Commencement speaker was selected by the university. It's an honor to be invited to be a commencement speaker. He or she has sort of the imprimatur of the university. They're invited because we think they have something worthwhile to say. So they're an official speaker. And therefore, I can understand that people have a stronger desire to make their views clear. It's true you can't engage in questions. You can carry signs in. I'm going to, I'll answer autobiographically at the risk of being too revealing. I was in the first class of women admitted to Yale College, and we were battling to get more women admitted. We were 10% of the undergraduate population, and I attended my college commencement. Well, my family gave me money. I was lucky to they said, you should buy a new dress for graduation. And I found a dress that was essentially a suffragette costume, which I wore, and I carried a big sign that said, "And male Yale," and that's my graduation picture. So there are many ways to communicate your views. And that was silent. It was respectful. It was not disruptive. It is totally permitted.
Thank you for your talk, Linda. I learned a lot, so I appreciate it, and especially your specific comments on AU, so I appreciate that. I'm wondering with the First Amendment and when it was written by rich white men, and free speech, especially offensive free speech, falls in the back of marginalized communities, sometimes, but not usually on rich white men. Mm-hmm. So how do you square that where we are in a different, I think we glorify what it was like at the time of the writing of the Bill of Rights and these things, and that was a time, and not we, like you specifically, but as Americans, we're like, oh, the founding fathers, right? But I'm wondering if those conversations would have been the same if there were women at the table, if there were black people at the table, if there were out LGBT people at the table, and we might end up somewhere different. And so how do you square our current wrestling with our historical past and wanting to preserve something that was written by people that it probably affects them the least?
That is a terrific and very sophisticated question. Thank you. And it goes to the heart of some big disputes about how we interpret the Constitution. So originalists, the more conservative justices, would say, rich white men, that's their view, that's where we are. Now, there's no question when you look at the Bill of Rights that has expanded to protect African Americans, other minorities, women. We aren't limited to the people who were at the table as a democracy, at the time of the founding. And the view that the Constitution is a living document that must adapt, I think, goes a long way toward resolving some of the issues that you're talking about. And yet you do have a point when the Chief Justice says the Constitution resolved that for us in the first instance. The First Amendment was written before we even had a 14th Amendment and while we had slavery. So there might be more room for looking at that. The problem is that once you open that values debate between dignity and equality and freedom of expression, then you are right in the middle of censorship based on viewpoint. And a lot of speech that many of us, probably most people in this room, find objectionable, racist speech, anti-Semitic speech, anti-immigrant speech, it has political components. And politics is at the apex of the expression that the First Amendment protects. So it's very hard to imagine, someone better than me might someday do it. It's hard to imagine how you restrict that kind of offense without really creating a lot of difficulty for free expression, because there's always the question, who's the person who is going to decide what is too offensive to be said? And the central principle of the First Amendment, which came from a response to living with a king, and that wouldn't matter whether there were women or black people or anybody else at the Native Americans at the table, was the government can never make those choices for us. We have to have a marketplace. Oh, I'm sorry.
Yes. So I wanted to ask you, because I found your remarks about creating another institution of emphasizing First Amendment rights to students alongside our current existing emphasizing of equality and diversity on campus. I found it a bit interesting just because I think, as useful as that's been, you really see this growth of transgressive, racist, sexist, very bigoted speakers peaking at the time we've institutionalized this. I think, and I really do appreciate it, but we've institutionalized this importance of equality and protection. And so these self-styled sort of, bad boys, kind of, oh, we're breaking the rules by being racists in public, come out of the woodwork. So I'm curious, given that recent event, how confident are you that making First Amendment institutionalized would really make people appreciate it? How can we not expect to see another kind of self-styled, transgressive, oh, the rules say this, but we stand against that kind of, outgrowth?
I think that's a very skillful framing. I like that concept of the bad boys using the First Amendment, and it's a real concern to people who take speech rights seriously. And it's related to what I said earlier about Milo. There isn't a way to pick and choose who gets to speak. And so what's most important is how we respond to transgressive events and whether we can communicate. Yes, everyone has the right to speak. That doesn't mean they get to suck up all the air out of the room, or that we ought to spend all our time taking them seriously if their ideas are really worthless. And I think one of the problems isn't just the growth of this transgressive speech on campus, but what's going on in our national politics that has suddenly made certain kinds of speech that we thought, depending on who you are and where you spend time, I think a lot of people have been taken aback by the outpouring of sentiments that we thought had really stopped existing, but instead had really been forced underground. And so one advantage of this speech is that we now know it's out there and we know what our work is if we seek justice and equality.
Hi. Thank you first and foremost for coming to American University. I really appreciate it. On the topic of free speech, when we talk about not just audio, the way we communicate in person, but also symbolic speech, how would you refer to how the Supreme Court, which is an institution, refers to cases like Texas v. Johnson and Virginia v. Black, which have such a distinctive difference about symbolic speech? How, as a society, can we see how these 9 justices come to a conclusion that are so vastly different?
Terrific. Are you an undergraduate? Yeah. I'm so impressed. I'm so impressed. Okay. For those of you who don't know, Texas v. Johnson is the case in which the court said that the flag is a symbol and it is an act of protected free speech to burn the flag for a political reason, to communicate political views. I'm sorry, and the other case you asked about was Virginia v. Black. Virginia v. Black is a case about true threats, and it involved cross-burning, and whether the state had to show that there was an intent to terrify in burning the cross. And I should mention one other important case, RAV, which was a case about a statute in St. Paul, Minnesota, that outlawed speech derogatory of certain groups, including African Americans. And the court quite surprisingly held, but it's a very important case, that that was a form of viewpoint discrimination, that you couldn't outlaw speaking about, let's say, racial or ethnic or religious groups in disparaging terms if you allowed people to say how great they were. That was viewpoint discrimination. So most recently, there was a trademark case, which is kind of an interesting, it was a rock group called the Slants, and they chose the name as a kind of ironic commentary on disparaging terms about Asians. They were all Asian. And the trademark office said, it's a disparaging comment, we won't trademark it. And they went to court and said, but we have a right to use it. The same has come up in a number of the college speech code cases going back to the 80s, where African-American basketball players went to court and said, we use the N-word a lot, and it's banned by our college code. And the court said, that's right, they can't ban it. All those codes have been overturned when challenged in court. So that is all of those decisions are consistent with the notion that controversial speech is what is protected. And you're right that Americans find these decisions really hard to understand. I'll say law professors found RAV hard to understand, so I'm going to set that to the side. But we repeatedly have members of Congress and the Senate trying to overturn the right to burn the flag. And I think partly they do it because it's a great political posture, and they know that it's never going to fly in, if it reaches the court again. But it's a popular position to say, patriotism, you can't burn the flag. What is our flag about? Our flag is about liberty. And that's one reason that I've spoken in support of the football players. To say what the flag requires is unquestioning standing up because that's the way people like you to do it, or that's the way the president wants you to do it. The flag is a piece of cloth. It gains its value from its symbolism about our deepest values and commitments. And the reason people fight and die for our flag, the symbol of our country, is because of all the rights that it gives us and the special nature of our society. And back in the 1940s, in another case involving the right of school children not to participate in the Pledge of Allegiance, the court said at the beginning of World War II, and talking about authoritarian countries that we were standing up against, and they said, this is really hard because the flag involved is our own. And that's where we test our commitment to freedom and to the right to disagree.
Hi. My question is about partisanship in protecting freedom of speech. So it seems like people on both sides of the political aisle often contradict themselves. So liberals are for safe spaces and trigger warnings, but at the same time receive a lot of backlash for groups like burning the flag or the NFL players protesting against the flag. So how do we ever get to a point where people support freedom of speech all the time and not just when it suits them for the issue they currently care about?
Wonderful. So this was something I actually had to cut out of my time. I'm so glad of my talk. In the 1960s, it was liberals and progressives who were battling for free speech. And more conservative people who were saying, who do they think they are, protesting the war, calling for civil rights for black people and voting rights and integration. We don't want to see these demonstrations. We don't want to hear about it. And today the tables have turned, and many of us in the free speech community are having a lot of difficulty understanding how liberals came to abandon the most important principle that has enabled every form of social change in our history. And that's why I like to remind people about the civil rights movement. If the state could decide what was too controversial to hear, I guarantee you that Mississippi and Alabama would have shut up, as they tried to do, every form of resistance during the 1950s and 60s by African Americans. So don't ever assume that the people you agree with are going to be the people making the speech choices. And we should all, in unison, support free speech, whether we're currently in power or we're currently out of power. Thank you. I would love it. You're a great audience.